let me then go straight to our first newsmaker tonight, the senior Supreme Court advocate, lawyer for Arvind Kejriwal, senior Congress leader and MP. Joining me now, Dr. Abhishek Manu Singhvi. Dr. Singhvi, how do you interpret this order? Because it was a split verdict between the two judges on whether the arrest was legal or not. Bail was granted. To you, what's the big takeaway?
I don't want to be technical, but it's important to understand some nuances. Firstly, the biggest takeaway is that both judges are unanimous that the person cannot be kept behind bars, must be given bail. In that process, they are also unanimous that bail is the rule, jail is the exception. They are also unanimous that huge delay, trial not even starting, forget completing, millions, thousands of witnesses or lakhs of documents, hundreds of witnesses, no chance of tampering, and therefore he must get bail. This is the unanimity part. The second big takeaway is that Justice Bhuyan goes and deals with a factual aspect. This is a very important nuance which nobody is talking about, Rajdeep. He deals with the factual context of no necessity to arrest. As your program just said, 3 dates show it. 22 August, then interrogated in 23 and then arrested in 24. There cannot be necessity of arrest is what he says. Now, Justice Surya Kant actually deals with the law part of it, namely 41, 41A, and says it doesn't apply in favor of Kejriwal, but does not deal with the factual aspect that even assuming that that law doesn't apply, a person who is not arrested for 2 long years, who has been given 3 release orders by PMLA, why should there be a necessity to detain him and keep him behind bars? So therefore, this is a gap. There is no dissent on that between the two. One deals with it and grants the relief. The other doesn't touch it. Number three, another misinformation going on is he can't sign any files. The order doesn't add a comma full stop to the order already passed on 12th of July in the PMLA case, Kejriwal himself, where I had the privilege also argue. Now that order says, and this is forgotten, Kejriwal holds no portfolio. He doesn't actually sign any files at all. The only category of files he must sign and does sign are the ones which have to go to the LG. So the Supreme Court order of 12th July made this distinction, said all matters where he has to sign, namely going to the LG, he can sign, which is continued today. The ones which are others, his ministers sign, he doesn't need to sign. And lastly, I think it's political to suggest that he cannot function as a chief minister. It is not something which I want to get into, but an elected chief minister cannot and should not be removed by these tactics. Now that he's out of jail and his ministers are signing files and he can sign the files for the LG, I don't think governance is any issue at all.
No, the fact is that, you see, Dr. Singhvi, there are 2 judges who have in some way differed from each other. Even on these conditions, they have differed from each other. Justice Bhuyan has gone as far away to say that the arrest was unnecessary, seemed to suggest that the CBI was acting like a cage parrot or needed to dispel the notion of a cage parrot. That's not what Justice Surya Kant says. You've chosen mainly one side to represent that. My limited point to you is, where does this leave the wider case of the liquor policy now? For the last 3 years, Delhi's politics, or 2 years at least, certainly Delhi's politics has been haunted by it. Where does this leave the larger case now?
2 things. You asked me the takeaway, so I gave you the convergence, the commonality. You are now giving the divergence, and you're absolutely right. There is a divergence, but the interesting nuance is the divergence is on one point of law, the inapplicability of 41 and 41A. There is no ruling by Justice Surya Kant on the factual context of no necessity to arrest.
No. Justice Surya Kant says that the arrest was legal. He says the arrest was legal.
On the basis that 41 and 41A don't apply. Now, that's an error, but there is a different issue. Error is not what we are discussing, because what Justice Surya Kant says is that when a person is already in custody, as Kejriwal was when the CBI came to arrest him, that police action or procedure is taken by the magistrate and the police has to do nothing. But forget that. On your other point, it's important that Justice Bhuyan has taken the overall context and, according to me, has rightly castigated this part. I was abroad when I used the phrase insurance arrest, because a man who's released by 3 orders, 2 prior and 1 later, in a much more difficult act, PMLA, it has never happened before that with Section 45 and a bar in PMLA, you get 3 release orders, including the 12th July order, and CBI comes and arrests you in the last third week of June. He did not use, the learned judge did not use the word insurance arrest, but he clearly said it frustrates. The strategy is to frustrate. Now your point about liquor. I don't think the liquor issue is going to end because it has become a nice whipping stick for the ruling party to use. They will continue using it. But the complete sting has gone out of it as far as the threat of incarceration is concerned. Let me tell you, the so-called fortress of the PMLA has actually become more like a hut, with even the hut's walls crumbling, because partly of the 6, 7, 8 judgments which have come in this liquor policy context and in a few related cases like Praveen Purakasthya or Kavita, etc.
Right.
So actually this fortress which is being used to intimidate political opponents has largely crumbled in robust, commonsensical, strong judgments, including this, despite the dissent. Despite the disagreement. I'm sorry, not dissent, disagreement.
One final question. You said earlier that you see this judgment not affecting Mr. Kejriwal's ability to continue as Chief Minister. The BJP has gone to the President of India. They've demanded that President's rule be applied. You've got a Chief Minister who cannot go to the office. He cannot go to the State Secretariat. And therefore, questions are being raised by the BJP. How can Kejriwal continue? Do you believe this judgment strengthens him or weakens him?
He can sign every file which he needs to sign, which has to go to the governor. He can sign sitting at home. He can sign in my house. He can sign in your house. And he can sign. He is not disabled from signing. Number two, this judgment obviously, contrary to what opponents are saying, may actually strengthen him. Because this judgment is a vindication of his release. Number three, he has been released twice earlier. So he has not been considered a threat to any criminality, Now, as far as the liquor scam is concerned, it's a strange thing. We have now 2.5 years of a so-called liquor scam. In 2.5 years, forget everything else, Rajdeep. You must find some money trail, some actual recovery. The CBI and the PMLA admits, the ED, they admit that there is no recovery, and they say there cannot be recovery because the money has been used up. But such massive amounts of money are talked about. Third facet of this, the entire case, I'm answering because you're asking about the liquor scam.
Yes.
90% of the case is based upon accused, co-accused, who are in jail, who have been denied bail, and then suddenly and miraculously get bail a few days, a few weeks after they turn approvers. It's based entirely on non-corroborated independent evidence. It is based on only the people turning approvers.
Let me leave it there, Dr. Singhvi. As always, of course, a pleasure talking to you, for giving us your perspective on a day where you've got your client on bail. Thanks very much.
Thank you.
Abhishek Manu Singhvi.